Reading from the Regulatory Guide, Reference Guide to Regulatory Compliance on page 513, Garnishment of Accounts Containing Federal Benefit Payments. Federal benefit payments are protected by statute from garnishment actions. This protection continues even when the funds are deposited into a transaction account. However, historically, there have been no requirements for financial institutions holding such funds to prevent the seizure in garnishment actions. Therefore, it was difficult for depositors to take advantage of this protection. The U.S. Treasury issued proposed rules in 2010 requiring financial institutions to conduct a look back upon the receipt of a notice of garnishment and allow the depositor to have access to federal benefit payments that were deposited in a garnished account within 60 calendar days prior to the receipt of the order. The proposed rule also required financial institutions to notify depositors of their right to protection of federal benefit payments. This rule was finalized in 2011. Coverage. Protected federal payments are those from the following agencies that are paid by direct deposit with the designation XX on the batch header of the ACH entry. ACH entry 1, 2, 3, and 4, Social Security benefits, VA, Veterans benefits, Railroad retirement benefits, and Office of Personnel Management benefits. An account is one held at financial institutions through which an electronic payment is likely to be directed. C. An account holder is a natural person who is the direct or beneficial owner of an account according to the records of the institution. And D. Financial institutions are entities chartered under state or federal law to engage in banking, such as banks, savings associations, and credit unions. Subpart 2, Requirements. There is a duty to examine an order of garnishment, and prior to taking any action related to the garnishment order, and no later than 2 business days following the receipt of the order by a financial institution, the institution must examine the order to determine if the federal government or a state child support enforcement agency has attached a notice of right to garnish federal benefits. B. If a notice of right to garnish federal benefits is attached, then the financial institution must follow its usual procedures for handling garnished accounts. If no notice of right to garnish federal benefits is included with the notice of garnishment, then the financial institution must perform an account review consisting of the transactions that occurred on the account within the 2 months preceding the date of the account review. This is called a look-back period, consisting of 8 steps. 1. The review must be conducted within 2 business days of the receipt of the order of garnishment and the receipt of sufficient information to determine whether the debtor is an account holder, if not already included in the order. 2. In cases where a large batch of orders is received, the financial institution may agree with the creditor to perform the review by a later date. 3. If the review determines that no federal benefits were deposited into the account during the look-back period, the financial institution must follow its usual procedures for handling a garnished account. 4. If the review determines that there was a benefit payment deposited into the account during the look-back period, the financial institution must act to protect those benefit payments. 5. In conducting the account review, the financial institution may not consider other commingled funds, the existence of a co-owner, the existence of benefit payments to multiple beneficiaries and or from multiple programs, the balance, D, the balance in the account provided that it is above 0, and instructions to the contrary if in the order, and F, the nature of the debt or obligation. 6. The account review must take priority over any other actions related to the garnishment order. 7. The financial institution must perform separate account reviews for each account in the name of an account holder that is subject to the garnishment action. And 8. In reviewing multiple accounts in the name of one account holder, the financial institution may not attempt to trace funds transferred between accounts to associate funds from a benefit payment deposited into one account with amounts transferred to another account. Subpart D, protecting benefit payments. If federal benefits were deposited into the account during the look-back period, the financial institution must act to protect these payments through the following 4 steps. 1. Protected account. The financial institution must immediately calculate and establish the protected amount for the account. The protected amount is the lesser of the amount of benefit payments posted to an account during the look-back period, or the balance in the account at the open of business on the date of the account review. The financial institution must allow full and customary access to the protected amount. This amount cannot be frozen, and the account holder does not have to assert any right to these funds. 3. Protected amounts must be calculated and established separately for each account. Protected amounts as calculated by the financial institution are considered to be conclusively exempt from garnishments. Excess funds, subpart E. Funds in excess of the protected amount are subject to the garnishment action. The financial institution must allow its usual procedures for such excess funds. Notice. The financial institution must provide a notice to the account holder named in the garnishment order. The notice must be sent in cases where a benefit payment was deposited during a look-back period and the account balance was above zero on the date of the account review and the financial institution established a protected amount. Notice must contain the following information in readily and understandable language, that is A, B, C, D, E, F, G, H, I, J, K, L, and M in this notice section. A, the financial institution received an order against the account holder shall be in the notice. B, the date the order was served. C, a succinct explanation of garnishment. D, the financial institution's requirement to ensure that account balance are protected and made available to the account holder. E, by identification of the account and protected amount established by the financial institution. F, the financial institution's obligation to freeze other funds and make them available to satisfy the order. G, any garnishment fee charged to the account. H, garnishment fees may not be charged to protected account balances, nor may such fees be charged after the date of the account review. And a list of federal benefit payments subject to this regulation. J, the account holder's right to assert further garnishment exemption against the creditor for amounts above the protected amount by completing exemption claim forms or contacting the creditor as applicable for the jurisdiction. K, the account holder's right to consult an attorney or legal aid service in asserting exemption rights above the protected amount. L, the name of the creditor and if included in the order, contact information. M, at its option, the financial institution may also notify the account holder of the following information. 1, 2, and 3. 1, means of contacting a local free attorney or legal aid. 2, means of contacting the financial institution. Or 3, a statement that by issuing the notice, the financial institution is not providing legal advice. So those are all optional clauses. 3, the financial institution may amend the notice to include state garnishment rules and protections for the purpose of avoiding confusion or providing more complete information. 4, the notice must be issued directly to the account holder or to a fiduciary who administers the account. 5. Only information and documents pertaining to the order, including other notices or forms that may be required by law, may be included in the communication. 6. The notice must be sent within 3 business days from the account review date. 7. One notice may be issued even if there are multiple accounts. And 8. The notice does not constitute legal advice and creates no obligation on the part of the financial institution. G. Other requirements. The requirements of this section do not limit an individual's rights under federal law to assert a further exemption from garnishment against a creditor. 2. This regulation does not invalidate any terms or conditions of an account agreement, provided that the term or condition is not inconsistent with this regulation. 3. Any state or local law that is inconsistent with this regulation is preempted to the extent of the inconsistency. 4. This regulation does not annul or alter any local or state law that is consistent with it. 5. The financial institution that complies in good faith with this regulation will not be liable to the creditor for failing to honor a garnishment order or for account activity during the 2 business days following the institution's receipt of the order, during which the institution is determining whether there is a notice of right to garnish federal benefits, and B. The time between the financial institution's receipt of the order and the date by which the institution must perform the account review. 6. The financial institution that complies in good faith shall not be liable to a creditor that issues garnishment order for any protected amounts to an account holder for frozen amounts, or for any penalties under state law, contempt of court, civil procedure, or other law when failing to honor a garnishment order when A. An agency has deposited payment into an account during in the look-back period, or determination was made that the order was obtained by the United States or state child support agency and initial action procedures were followed. 7. The financial institution that complies shall not be liable for providing in good faith any permissible optional information. 8. A financial institution is not liable for bona fide errors that occur despite reasonable procedures maintained to prevent them. And 9. Financial institutions are not liable for customers' clearing and settlement adjustments that affect the balance in an account, including deposit reversals caused by a return of unpaid items or debit card transactions settled for amounts higher than the amounts originally authorized, or for honoring the account holder's express written and dated instructions to the financial institution to use a protected amount to satisfy the order. Record retention. Records must be maintained to demonstrate compliance for a period of 2 years from the date the financial institution receives a garnishment order. And the federal banking agencies are responsible for administrative enforcement. The FIRA penalties are $7,500 per day for violations, $37,500 per day for violations or unsafe or unsound practices that are engaged in recklessly or are part of a pattern of misconduct that causes more than minimal loss to the bank or any pecuniary gain to the parties involved, and penalties of up to $1.375 million per day against persons who knowingly commit a violation and knowingly or recklessly causes substantial loss to the bank or a substantial benefit to the party. I would say that there's some things in here that don't exactly make a lot of sense, which is fee income. So, for instance, or even what to do after freezing the funds. So after freezing the funds, are the funds to be delivered to the federal agency? Is the federal agency going to give the bank instructions with what to do with those frozen funds? And then about returning items when there's no funds in the account to pay the items or the funds are frozen. NSF fees, that is, are they allowable? And then there is a fee allowable for performing the garnishment, but I don't think that it can be charged against a protected amount. It can only be charged in excess of the protected amount, and can the account go into the negative? These are questions I wish were more clearly described.